And Aduchi, the question then is, why this posture?
Okay, so it's important that matters are put in proper perspective. You see, the 1992 Constitution mirrors our history, how checkered our history has been. So if you recall, in 1979, Kwekuba got elected as a member of parliament on the ticket of a political party. He comes to parliament and within some whatever says he's no longer a member of that political party. But he still wants to remain as an MP. And in fact, remain as an MP until the 1981 coup d'etat. Now, with this background and the fact that a major political party, possibly with the benefit of money or anything, can induce somebody to quickly cross carpet to another end or even leave his own political party. So when the 1992 Constitution was being put together, mindful of this history, we inserted Article 97G. And the whole essence of that constitutional provision is to say that if you are elected on the ticket of one party and you come to parliament, for whatever reason, you must remain there. If you decide voluntarily that you want to leave that party to a different political grouping or party, you should forfeit that seat by way of vacancy declaration. Now you note that, for instance, Professor Wayoseni came to parliament on the ticket of the NDC, even though he used to be an MPP member. Then in 2006, for whatever reason, said he's no longer an NDC MP and that he had cross-carpeted to the other. Then we said, no, the Constitution doesn't. That by-election brought lawyer Inus Afuseni. All these things mirrors a particular history. Then came 2020, where in this case, an NPP MP, in the person of Andrew Esiama, lawyer, took the initiative to contest the 2020 election as an independent candidate. Now, when he took that decision, his party cited the party's own constitution to say a member who takes such an enterprise forfeits his membership. And since he's no longer a member of the NPP, he cannot continue. What is required in those circumstances is the declaration of intent. That declaration of intent of formally filing. And in this particular case, all the affected individuals, Honorable Kwachiaka, had actually filed his nomination with the Electoral Commission as an independent. Honorable Andrew Esiama had filed his nomination with the Electoral Commission as now MPP candidate. Morrison, what's the name? Cynthia Morrison had also filed his nomination. So the issue of them filing their nomination is a matter of fact. No dispute whatsoever. So when the minority leader then, now majority leader Case Lato Forson, raised the issue, the speaker considered it worthy to give a ruling. But you see, like I always say, when this matter came to the speaker, he exercised a lot of sobriety, a lot of patience, and said, look, give me 2 days to consult broadly and deliver a ruling on it. And therefore, he delivered his ruling. Now, guess what? What was the ruling of the speaker? The ruling said, look, I am aware of a precedent set by my predecessor, Professor Michael Kwe. However, I am not bound by that precedent. But looking at these facts, I am minded to do what the Constitution says should be done. What is the issue? Now, prior to that, Alex Afenyo-Markin had gone to the court. Now, listen carefully. To even stop the speaker from going ahead with the declaration by way of an injunction, the speaker gave an indication that he has not been served with those processes and proceeded to deliver his ruling. Guess what? What Afenyo-Markin was seeking was an injunction to restrain the speaker from making the declaration. The speaker had declared those seats vacant and they stand vacant. How do you reverse that process? Because as at Friday, when Afenyo-Markin went to court He had not amended the original action. It is the original writ that invoked the jurisdiction of the Supreme Court. Now, you cannot put an application on nothing. An application should be mounted on an existing action. So the originating motion is not the application. It is the writ. That is what invokes the original jurisdiction of the Supreme Court. Now, Afenyo was seeking to stop that thing from happening. As at the time he went to court on Friday, that thing had happened. Like we always say, you don't grant an injunction where the horses are bolted already. The injunction is to stop the horses from moving. Now the horses have moved. So what would be the basis of granting an injunction? So you see, the court then cleverly said, then they are staying the execution. The fundamental question every lawyer will ask, the decision by the speaker, the ruling by the speaker, is it an executable order? If it is not an executable order, what would be the basis to say it? Two, I have gone through the law reports and I've been trying to look for a precedent where the Supreme Court of Ghana from 1992 per an ex parte application stayed the execution of an order. There is none. Are there anybody to do that? In fact, if you recall, Tenadi, even that one, the Supreme Court had to do an extraordinary step of restraining the Electoral Commission. It was on notice. A major matter of this nature, to grant an ex parte application makes it extremely strange and bizarre. But you see, I have looked at the reasoning behind the Supreme Court's decision to stay the execution of the order. One, the Supreme Court says there are special circumstances. What is special about it? Did the Speaker stop now minority from conducting the business of government in the House? They voluntarily walked out. Now, where a person has a right to conduct government business and that person voluntarily walks out of Parliament, how can that same person now complain that it will affect government business? In any case, walkouts are legitimate exercise of parliamentary work. And that is why all over the period from 1992 to date, even when there have been walkout, business of government had always run. So it was so strange that the Supreme Court now relies on a purported whatever frustration of government business. At that point, the Supreme Court had now moved into the realms of politics. It is no longer law, but it's doing politics.
How can you accuse the Supreme Court of meddling in the daily affairs of the politics of the country?
Because you see, the running of government, the governance, is an executive action. So when, for instance, the executive brings a bill to Parliament, and you are saying that by reason of the ruling by Speaker, that bill cannot be taken, that is a different matter. In this case, Afenyo Makin instructed his group to walk out. He was not denied the opportunity to transact government business. When he voluntarily decided to walk out, it lies foul in his mouth to now complain that government business will be affected. So the very moment the Supreme Court cites this instance as one of the grounds to stay the execution, they are now doing politics and not law or policy formulation. And you see, there's always a danger with the court, activism. Look, I'll tell you this. Jachi Kwesi, who injuncted Jachi Kwesi from performing his duties as a member of Parliament?
How do you mean?
Who injuncted him? Was it not the Supreme Court?
The court, yes.
From 1992, do you know any MP that has been injuncted before? Do you know? The panel that injuncted Jachi Kwesi included a CJ.
The current CJ?
Yes. At the time when they injuncted Jachi Kwesi, the people of Asinop were not denied representation until the by-election.
Why is this important?
Because the court now says that these persons whose seats have been declared vacant will be denied representation. Is that a double speak? When the court injuncted the Honorable Jachi Kwesi from performing his duties pending the determination of the action by the Michael something, the court was not mindful that the people in Asinop will be denied representation. Now you see, the curious thing about all of this is that the Supreme Court says these people will be denied representation. Curious. We have been in this country when one morning the Electoral Commission on the 6th of December, by a stroke of pen, denied the people of Central Kofi, Akpafu, Likpe, Lolobi representation in Parliament.
Are you accusing the Supreme Court of double standards?
I am saying that we were in this country when the people of Central Kofi, the people of Akpafu, Likpe, Lolobi were denied representation for 4 years at the time where matters were in our courts. In fact, when a court took the extraordinary step of injuncting Amewu, the Supreme Court intervened by way of its supervisory jurisdiction to quash that. Look, I have always maintained that we are building a constitutional democracy. This constitutional democracy that we are building, we need to carry our people along. Where the impression is being created that when the action borders on Kwejo, the speed, the alacrity with which it is dealt with, but when it has to do with armor, laxity, it creates a certain impression. And I say this, I represented the NDC, yes, September last year. We issued a writ because the EC had, planned conducting the limited exercise in their district offices. When we went to the court, guess what happened? When we went to the court, it was the vacation. When we went in, guess what? The registry of the court gave us October, by which time the EC would have been done with the exercise. October. Meanwhile, in 2012, when Afarijan decided to create the additional 45 new constituencies, Ransford, France went to court led by my then company law lecturer Joe Gatti to stop the process. It was during the legal vacation. The then Chief Justice George Nawood put up a sole panel. Justice Julius Ansah, may he so rest in peace. He presided over the matter during the vacation and gave a ruling. For me, my point is that the application of these rules must appear even. Look, justice delivery is founded on public confidence. Public confidence in the sense that when Eduji and Roland have a problem, we should have the confidence that when we go to court, the outcome, whatever it is, we will take it. But where we have any doubt that we'll go and this and that is what will happen,
Eduji, wrap up.
Eventually what you have is what we call self-help. Because then when you have the problem, you don't want to go to the court. What you want to do is to take the law into your own hands. And that is why I find this ruling by the Apex Court extremely concerning. It doesn't send the right signal to our people.
What sort of signal does it send, Eduji?
You
are an officer of the court.
Yes, and that is why I'm even more concerned. That is why I am even more concerned. Because listen to me, as Director Legal of the NDC, I have an important role to advise the party on key legal issues. With the things happening, what would be the basis on which I will look my party in the face and say, take these A, B, C, D steps? Because my own people will tell me that, Eduji, you say we should go where? We should go to court. And so I am saying that we have gotten to the point where the rulings coming from, particularly the Apex Court, relative to matters with political undertone, do not send the right signal.
No. Kwesi Kwarteng, what do you make of all this? Because